Oh na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Big it up. Oh na 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 na. Big it up. Oh na 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 na. Bam bam. Bir bam bam bir bam bir de. Bir bam bam. Bir bam bir de. Bir bam bam bir bam bam bir bam bir de. Bir bam bam. Bir bam bir bam 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 bam. Bir bam bir de.
Good day, everyone. Welcome to Home and Away, Jamaica, where we connect Jamaica with the diaspora. Your host, Robert Taylor, Taylor Law, and with me today is co-host Stacey Salmon, Taylor Law partner as well. And we are joined today by a guest. What we will do, as we've done in some other shows, is have our guest, or on behalf of our guest, we will pose a legal question, property related, and we will respond with our advice. So, good morning. And I will start with a question. So, my mother passed away in 2014 and left a house in Jamaica, which a family member has a title in Jamaica currently. So, our guest lives overseas. There is no written agreement from me or my mother in regards to the persons leasing the property or consent from my mother to allow the family member to lease the property. The house does not have any electricity, but is powered by electricity, which is not from the property, and has water on it. I do not know how, but has a person living there without my consent, which was a result of that family member. I've asked numerous times for the persons to be removed without trying to ruffle the feathers, as I do not want any problems. I do not want to do anything to the house while someone is occupying. I want to know, how can I go about getting the persons removed from the property, and is it possible to add my name to the title through inheritance? So, Stacey, this seems like a very common situation. How would you address this response? And what are some of the questions you would ask our guests in doing so?
Okay, sure. So, Robert, this is a pretty common issue that comes up, in our day-to-day practice. So, seeing as though there is no lease in place, there is no oral or written agreement between the registered owner and the occupant of the property, what our guest's best option is to serve the occupant with a notice to vacate the premises. Once the expiration date, typically in a notice to vacate, the occupant is given 30 days to leave the premises. On the expiration of that 30 days, if the occupant remains in the premises, then our guest would have to pursue legal recourse through the courts. And this is by way of a recovery of possession suit in the parish court where the property is located.
Okay, great. So what I'm seeing from the question, there are two issues.
Right.
One of this person who is in possession, unauthorized possession, and two, the issue of taking ownership through her mother's ownership as well. And so the issue of probate. How would you address that aspect of the question?
So first, I'd like to ask our guest, did your mother have a will in place?
No, she did not.
She did not. Okay. Was your mother married, or does she have any other children?
No, I'm the only child and she was not married.
Okay, so because there is no will, instead of applying for a grant of probate through the court, you would have to apply for a grant of administration. So this is where an administrator is appointed to wind up the estate rather than an executor that's named in a will.
Okay.
Right, so once the application is made for the grant of administration and the court issues that grant, then you will be authorized to deal with the property and transfer it in your name.
Okay.
So, Stacey, I have some other general comments and concerns. So, there is a relative who seems to have some level of control over the property because it seems they are the ones that instituted this act of authorizing possession. And so, you know, my suggestion would be that that has to be looked at very carefully in the event that relative takes steps to dispossess or guest from their beneficial interest in the property. And so I think, and we understand our guest isn't in Jamaica, but this certainly needs some act of physical presence, either by our guest or by someone who she can rely on. But in these situations, when you're very far removed, it gives you very little control or effective autonomy in displacing someone who is in possession. And so persons who know that the rightful owner is living overseas can generally take these steps to the disadvantage of the person with this beneficial interest. So that's something that I think we would advise, that as soon as you can have physical presence in Jamaica, you should, or have someone that you can rely on take steps to dispossess, or as Stacey has mentioned, serve the relevant notice. Issues in terms of water and electricity, it's possible they're getting electricity from the public domain. It's not uncommon in Jamaica, but that's not something that you have direct control over. If you wanted to make a report, you could possibly file a formal report to the public utility, Jamaica Public Service, and let them know you suspect electricity is being used illegally.
Okay.
And I think those are the direction of our advice generally. The other thing I would say is you also have to bear in mind, I'm not sure, where in Jamaica is this property?
It's in Greater Portmore.
Oh, it's in Greater Portmore. So it's in one of the schemes in Portmore, in Greater Portmore.
Yes.
Okay, so I would imagine the property has considerable value.
Yes.
And it's something that you would want to take active steps to control. You wouldn't want undisturbed occupation to take place over a considerable period of time, as those persons, whether it be your cousin or the person in possession, could take steps through the law of adverse possession to displace your interest. And as Stacey mentioned, the act of seeking letters of administration is not as speedy as applying for a grant of probate. So it's something you'd want to start very, very quickly. The other thing, Stacey, we possibly could suggest to our guests is an application for a caveat to protect her beneficial interest. And when we say beneficial interest, we distinguish a beneficial interest from a legal interest. A legal interest is when your name is on title and indisputable. Beneficial interest means by way of this inheritance, you have a benefit. That benefit has not yet converted to a legal interest. So we use the term beneficial interest, which is still an interest that is recognized in law, just it's one rung below a legal interest.
Okay. Can anybody do a caveat?
Well, in this instance, what would be done would be an affidavit or declaration where you would basically give a statement to the registrar of titles explaining the basis by which, or the basis under which you are entitled to this interest. And the registrar would review this declaration, make a determination. And if it is determined you have this interest to protect, then the application will be granted. And there is a cost associated with that application as well.
Okay.
Stacey, have I left anything out?
No, I think you covered everything pretty comprehensively.
Okay. Any further questions from us? Were we clear in our advice?
Yes, it was very clear. Thank you. Just wanted to ask one question. In regards to the person or the person occupying the property or the person that has the land title, what is the period in which they can essentially have an interest in the property? Because it's been quite some years now and I'm a little bit worried about the time frame.
Well, the first thing I would suggest is that you get a copy of the title. So the person who has a title really has what we call a duplicate certificate of title. The original title is with the registrar of titles. It's with the titles office. So you can go online, you'd have to establish an account, or at some other point speak to our office and we could retrieve a copy of that title. And so the title or the copy of the original that's with the registrar of titles is scanned and it's available for viewing online. So you can retrieve a copy just to make sure that the property remains in your mother's name. It is highly unlikely that a transfer could be done. It would have, I think, to be through fraud. But for anyone to transfer your mother's interest to themselves, the transfer would have to be effected by way of letters of administration, and that person would have to prove that they're either your mother's sibling or child or spouse. Presumably, there could be a fictitious sale where someone does a sale agreement transferring from your mother's name to another party. Again, that would be by way of fraud because your mother's signature would have to be forged. And so we would surmise that it's probably unlikely that anything has happened. Also, the fact of the title being in their possession doesn't prevent you from taking steps. You can always apply to the registrar for a duplicate title. They will cancel the title that's in the possession of that relative.
Okay.
All right, and just to answer your question, the period of time would be 12 years for them to take steps to adversely possess the rightful owner.
Okay, thank you.
Right, so you've said that, your mother has passed some time, so you have to take that into account as well.
Okay.
Well, if there are no further questions, we want to thank you. Thank you for providing some very useful content for our program. And if you have any other questions, I'm sure you will reach out. So thanks again. And bye for now from both myself, Robert Taylor, and Stacey Salmon, Home and Away, Jamaica. Until next time.
Thank you.
Thank you too.
Thank you.
Bam, bam.